There's the High Court, the Supreme Court, the County Court, the Magistrates Court. It is, Madam Acting Deputy President, a labyrinth, with top lawyers commanding fees of $10,000 a day or higher for their services. According to research by IBIS, legal services in Australia are a $21 billion industry, employing nearly 100,000 people. It is, Madam Acting Deputy President, a gravy train with many, many carriages. But for the moment, I would like to drill down into one aspect of this labyrinth, the family court. In many ways, this is both the most important and the most divisive part of our legal system. I say that because it goes to the heart of Australian society, our families and our children. The current state of the family court points to a tragic legacy left behind by the previous government. The Family Law Legislation Amendment, Family Violence and Other Measures Act 2011, was passed by the Senate and came into effect in 2012. This legislation changed the Howard government's shared parenting reforms via a spurious claim to provide greater protection for children from family violence. The objective was to improve the family court's decision-making by giving priority to a child's safety when determining what is in their best interests. The aim was also to make it easier for allegations of family violence and sexual abuse to be brought before the court. And was this successful? Last year, a retiring family court judge gave his view, which was reported in the Fairfax Press. Justice David Collier had 14 years on the bench. And keep in mind, Madam Acting Deputy President, it is rare for family court judges to speak publicly about their views. Many of us would recall the 1980 murder of Justice David Opus and the 1984 bombings of the Parramatta Family Court building and the homes of two judges. The family court is the flashpoint for the breakdown in family life. It is a place of heat and anger and stress. It is a place where lives collapse and are changed forever. And Justice Collier gives us clear insight into what's currently forging this tragic metallurgy of Australian families in crisis. He said unprecedented hostility was infiltrating the family court, with a willingness by parents to use their children to damage one another. Allegations of child sexual abuse are being increasingly invented by mothers to stop fathers from seeing their children, Justice Collier said. I quote from Justice Collier, "When you have heard the evidence, you realise that this is a person who is so determined to win that he or she will say anything. I am satisfied that a number of people who have appeared before me have known that this is one of the ways of completely shutting husbands out of the child's life." Justice Collier called this a horrible weapon. The continued use of false claims is undoubtedly fuelling the crisis of our family court system. Member for Dawson, George Christensen, has been a strong campaigner against our unfair family law and child support systems. He referred to the Gillard government amendment as a Trojan horse, loaded with consequences that would undermine some of the most basic human rights of both parents and children, and particularly fathers. This reform to the Act provided for two primary concerns for the family court to consider when making parenting orders. The first concern was the benefit to the child of having a meaningful relationship with both of their parents, and secondly, the need to protect children from harm and abuse. On the surface, both of these seem valid. However, the Gillard Government Amended Act clarified the second primary consideration of violence over the shared parenting provisions. Where there is conflict between these two primary considerations, the Act now requires the courts to give more priority to the protection of children from harm and abuse. Good idea? Of course it is in principle, but this amendment has allowed the introduction of many false allegations in the court and to many family court practitioners, the judges and the clerks, the barristers and others, the system is on the brink of collapse. The Chief Justice of the Family Court of Australia told ABC Radio earlier this month cuts to legal aid have led to more and more people representing themselves. Justice Diana Bryant said the family court system was unquestionably compromised. She said the family court produces decisions that don't stick, and then you have people who are unhappy with decisions or who take matters into their own hands. Justice Bryant said there are mental health issues, and the court needs to know about those issues and to know the extent of them. And you don't have parties with the capacity to bring the right evidence, then you are certainly putting children at risk. And aiding this breakdown of the family court system was the repeal of sections including 60cc 3C, which were known as the friendly parent provisions. This meant the court is no longer required to consider the willingness and ability of a parent to facilitate a relationship with the other parent in determining the best interests of the child. Reforms by the Howard government were designed to get away from the adversarial system and allow a court to consider giving custody to the parent, who was most likely to include the other parent in the children's right to have a meaningful relationship with both parents. Additional consideration of under the aforementioned section also requires the court to consider the extent to which each parent has fulfilled or failed to fill his or her obligations to maintain the child. This includes the extent to which the father or mother has taken the opportunity to participate in decision-making in relation to the child, as well as spending time with and communicating with the child. As divorce is no fault, the reasons for failing in this area are seldom considered, so parental alienation becomes a successful tactic. One parent presents an accusation against the other parent for failing to be involved. Excluding the other parent becomes the grounds to further eject the alienated parent. Additionally, hearsay evidence of children is now allowed in family court proceedings. The provisions of the Evidence Act 1995 do not apply to child-related proceedings, and the Gillard government repealed the section which allowed the courts to order costs against a party who has been found to have knowingly made a false allegation or statements before the court. This means any accusations can be made in a family court hearing with impunity. Frequently we hear unsupported accusations of abhorrent behaviour by one parent. As I said earlier, Justice Collier called this a horrible weapon. And lastly, we operate under a new definition of family violence. This means family violence now means just about anything. So it's open slather, Madam Acting Deputy President, claim and counterclaim, and a veritable river of unsubstantiated accusations in family court proceedings. A survey of 68 New South Wales magistrates concerning apprehended violence orders, AVOs, found 90% agreed, and some AVOs were sought as a tactic to aid their case in order to deprive a former partner of contact with their children. About a third of those who thought AVOs were used tactically indicated that it did not occur often, but 1 in 6 believe it occurred all the time. A similar survey of 38 Queensland magistrates found that 74% agreed with the proposition that protection orders are used in family court proceedings as a tactic to aid a parent's case and to deprive their partner of contact with their children. Madam Acting Deputy President, it is time to ask ourselves if we are falling short of the ideal professed under the international human rights of the child. Included in this are the child's right not to be separated from his or her parents against the child's will, the child's right to maintain contact with both parents if they separate, the child's right to be heard in any judicial and administrative proceedings, the child's right to freedom of expression, and lastly, that parents or legal guardians have the primary responsibility for the child's upbringing. As the member for Dawson said earlier this month, family law and child support are messy areas, and there are no winners. But under the current system, some of the losers are being turned into massive losers, even to the extent of losing their children and their lives. The current system is blatantly unfair and negligent. It is biased against fathers. It is unfair to children, the most vulnerable members of our communities, and it must be fixed as a matter of urgency. Thank you.
Thank you, Senator Madigan.